Judicial Watch has gotten or caused the removal of 4 million names from the voting rolls. 4 million. That's a big percentage of the total voter registration population in the United States. That's just in the last year or two. So Judicial Watch, to move on to the next topic, which is the integrity of our elections, is a national leader in protecting the integrity of our elections, ensuring the elections are as fair and clean as possible within our capacity. And I just did a video, coincidentally, the other day, talking about some of our work.
Hey everyone, Judicial Watch has major lawsuits ongoing in federal court against Illinois and California to clean up the voting rolls in those states. Millions of names are at issue, and of course we're not only fighting the states, but the extremist left that, for whatever reason, wants dirty voting rolls. Support our work. We've got more litigation coming as well. We can't do enough in terms of heavy lifting to ensure clean and fair elections.
As I said, more is coming, and I kept the promise, or my colleagues in the election law section of Judicial Watch did, by warning Oregon that we would sue them unless the state cleaned up the rolls as federal law requires. And Oregon's voting rolls are a mess. As I noted, we already had lawsuits that could impact millions of names in terms of ultimate removal in Illinois and California. And Oregon's rolls are a mess as well. And under the law, we're supposed to give them warning before we sue. And so we sent them the warning letter, and I want to read from it because it's educational, because it explains what the law is and what needs to be done, not only in Oregon, but maybe in your state and locality. Dear Secretary Griffin Valde, who is the Secretary of State of Oregon, I write on behalf of Judicial Watch, the Constitution Party of Oregon, and SUNY Danforth to notify you that your office is currently in violation of Section 8 of the National Voter Registration Act. We write to you as Oregon's Chief State Elections Officer, responsible for coordinating Oregon's compliance with Section 8 of the NVRA. This letter serves as a pre-suit notice pursuant to the law that Judicial Watch and our clients will file a lawsuit against you if these violations are not corrected within 20 days. As you are no doubt aware, the NVRA was intended, quote, to increase the number of eligible citizens who register, unquote, and to protect the integrity of the electoral process, and, quote, to ensure that accurate and current voter registration rolls are maintained, close quote. The goal of ensuring election integrity was embodied in Section 8, which requires each state to conduct a general program that makes a reasonable effort to remove the names of ineligible voters from official lists of eligible voters by reasons of the death of the registrant or a change in the residence of the registrant. Meaning if someone dies or moves away, you got to try to figure out how to track that and remove their names from the rolls. It's simple. And the fact it's not being done is really inexcusable in this day and age. That's not in the letter, but that's what I think. The registration of a voter who may have moved may only be canceled in one of two ways. First, it is canceled if the registrant confirms a change of address in writing. Second, if the registrant has sent a postage, prepaid, pre-addressed, forwardable notice requesting address confirmation. The confirmation notice fails to respond to it and then fails to vote in the next two general elections, that registration must be canceled. So I want to pause there. So what the letter is saying and what the law requires, it's really simple. If you don't vote in a federal election, you're supposed to get a postcard. And the postcard should say, hey, we missed you. You didn't vote. Are you still there? I'm paraphrasing. And if you don't respond to that postcard saying, I'm still here, or otherwise vote in the next 2 federal elections, your name's removed. Simple. And that could take, 4 or 5 years. I mean, 2 federal elections, plus the prior election, maybe 6 years, as long as 6 years. So the idea they can't get their act together to do that simple list maintenance is just unbelievable. And that's why we've had great success in the past in either lawsuits or the threatening of lawsuits in getting jurisdictions to clean up the rolls. I mean, just in the last year or two, Judicial Watch has gotten or caused the removal of 4 million names from the voting rolls. 4 million. That's a big percentage of the total voter registration population in the United States. That's just in the last year or two. Going back to the letter. Registrants who have failed to respond to a confirmation notice and whose registrations will be canceled after the statutory waiting period are said to be, quote, inactive. However, inactive registrations may still be voted on Election Day. And that's another little thing they hide behind. They say, oh, well, they didn't vote, but they're inactive, and don't worry about it. Because we don't necessarily treat inactive voters the way we do active registered voters. Well, that doesn't matter because they can all show up and vote. And the danger is that the names of people who have moved away or otherwise aren't able to vote or ineligible to vote are a pool of names from which fraudsters can vote. That's why you're supposed to have clean names. That's why you're supposed to have clean lists. I mean, it's not rocket science. And the NVRA also contains a public records provision. And this is a provision any citizen can use, by the way. So take note. Section 8I requires that each state shall maintain for at least 2 years and shall make available for public inspection all records concerning the implementation of programs and activities conducted for the purpose of ensuring the accuracy and currency of official lists of eligible voters. So you can ask your state or county or jurisdiction of that has that runs these voter programs, voter registration programs, and list maintenance activities for records about what they're doing in terms of ensuring the rolls are clean. That provision goes on to specifically provide that the records maintained shall include the lists of the names and addresses of all persons to whom address confirmation notices are sent and information concerning whether or not such person has responded to the notice. Federal law also requires the Election Assistance Commission, which is a federal agency, to submit a report to Congress every second year assessing the impact of the NVRA on the administration of federal elections during the preceding 2 years. Federal regulations require you, Oregon, to provide data to the EAC for use in this report, specifically including the total number of registrants statewide. I was using the screen to read. That were considered inactive at the close of the most recent federal general election. The EAC posted the most recent survey it sent to the states to elicit their responses for its biennial report. On June 20th, 2023, the EAC published the data it received from the states, including your state, in response to this survey for the reporting period from November 20 through to November 2022. So what does that all mean? It means you're supposed to make the documents public, and you're supposed to tell this federal agency what you've done to clean up the rolls. And what Judicial Watch does is we look at that data very carefully to see that you're doing what you're supposed to do under law. That's the states should be doing what they should be doing under law, and the counties, obviously, within the states. And that's where issues arise. And that's where they arose here. In the next section of the letter, facts showing violations of the list maintenance provisions of the NVRA. According to your state's responses to the EAC survey, 19 Oregon counties reported removing 0 voter registrations from November 2020 to November 2022 pursuant to that section of the NVRA for failing to respond to a confirmation notice and failing to vote in 2 federal consecutive general elections. Another 10 counties reported just a handful of such removals during the same 2-year period. Furthermore, not a single one of Oregon's 36 counties reported any data whatsoever to the EAC regarding inactive registrations. Instead, in the relevant column and where the data should have been, the survey response for each of Oregon's counties merely stated data not available. So think about that for a minute. So you had a bunch of counties who have not removed any names under this process, and a bunch more counties who don't know what they've done. They didn't report any information. So 0 or we don't know. Well, that means they're not doing what they're supposed to do under the law. Hence our warning letter. And we wrote to them on August 24th, 2023, pointing out these facts and asking you to confirm the data contained in the EAC's report and to provide the data that was omitted. So we're giving them another chance. And we also asked for records under this public records section of the NVRA. On September 15th, your office responded by means of an email which treated our factual inquiries about the aforementioned county data as requests for public records. Neither the person who sent us the email nor anyone within your office ever provided any substantive response to our request. Both common sense and Judicial Watch's enforcement experience, which, as I note, is significant and incomparable nationally, that there is no possible way Oregon has complied with the law, mainly the key NVRA provision dealing with voters who change residence, when 28 of its 36 counties either removed no or just a few registrations under that provision during the past 2 reporting years, and when all 36 of its counties failed to report any data regarding inactive registrations. These facts show that Oregon is not complying with its list maintenance obligations to, quote, conduct a general program that makes a reasonable effort to remove the names, unquote, of voters who have moved or died. Again, we're not asking for all sorts of things. Well, we just want them to do it doesn't even have to be perfect. You can miss a name or here and there. We understand that's the case. But if you're not removing any names, it means you're completely outside the law. And that's why we don't send these letters without having a real good understanding and concern about the failures to remove the names. I mean, some states you might think, well, you know, they may not be doing exactly everything they're supposed to be doing, but it's not enough to kind of trigger a lawsuit. You may kind of yell a little bit about it. Here, I mean, this is going to be a lawsuit if they don't get their act together. And this is another interesting fact. Oregon's noncompliance with the law is further illustrated by the unusually high registration rates observed in several of its counties. Comparing the data your state reported to the EAC regarding the total registration of each county to the U.S. Census Bureau's most recent 5-year estimate of the numbers of resident citizens over the age of 18 suggests that 8 Oregon counties have more voter registrations than citizens of voting age. Several federal courts have determined that such high registration rates are sufficient grounds for alleging a failure to comply with the requirement to make reasonable efforts to remove names by reason of death or change of address. And we've long experienced, we go on, you know, after saying you need to get back to us, with list maintenance litigation and are well aware of the practical difficulties jurisdictions face in trying to maintain their voter rolls. We're always glad to avoid costly litigation and to amicably resolve disputes. Please contact us if you have any questions. And Bob Popper, who is our lead election lawyer, former Justice Department official, senior civil rights litigator, signed the letter for us on behalf of Judicial Watch and our clients. I mean, the point is, we don't want to sue if just telling them that there's a problem will get the records cleaned up. And I love that fact about having people on the rolls in numbers that are over the number of people eligible to vote. So this is, again, the simple explanation, or at least I think is a simple explanation. If you have a list of voters and that list has more people on it than are actually living there and eligible to vote, that's a pretty good indication you're not maintaining the list properly. It means you've got extra names. Simple. And as I said, we've got this tremendous record of getting voter rolls cleaned up. California, we've got new litigation in California, but we had prior litigation in California that caused the county of Los Angeles in our settlement to remove, what was it, 1.2 million names from the rolls. I think it was just last year. New York City removed 440,000 names from the rolls after we called them out on it. Here in D.C., they removed 138,000 names from the rolls. Pennsylvania cleaned up their rolls. North Carolina cleaned up their rolls. Kentucky, there was a consent decree. They cleaned up their rolls. Colorado cleaned up their rolls. And now we have a case in Illinois to clean up their rolls. We know what we're doing, and we know enough about the law, and we're expert in analyzing data here, and our expertise has been acknowledged by the courts to know there's something going on in Oregon. So who knows what will happen? Maybe they'll just say, Judicial Watch, you're right. We'll clean up the rolls, and we won't have to sue. Or we'll sue and they'll settle or something like that. But we'll see. Again, we're supposed to ignore election integrity. I know the left doesn't want to talk about election integrity. We're not going to ignore it. We're going to go to court over it. We're already in court. We've got 2 federal court cases to clean up election rolls in Illinois and California. We have 2 more cases to stop the counting of ballots after Election Day. Illinois, they count ballots that arrive for 14 days after Election Day, including ballots that aren't postmarked. Mississippi, 5 days. I think it's 9 or 19 other states have similar laws. California, I think they count ballots that arrive for up to 7 days after the election. I mean, first of all, it's illegal, at least our understanding is, under straightforward federal law. It's Election Day is Election Day. And talk about like providing an opportunity for voter fraud and undermining confidence in elections, counting ballots that arrive after the polls close. So we're going to do the heavy lifting in the run-up to the election. We're going to do the heavy lifting after the election. And for as long as it takes to ensure that these failures, numerous failures to clean up the election rolls are addressed, that regulations that allow the counting of ballots outside the lawful time are thrown out, but we're just going to keep on fighting for clean elections. And we're going to oppose regulations that undermine clean elections in a way that's inappropriate or illicit. We're just never going to stop. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.